Hello, my name is Edison Titus with the Titus Law Firm, and the Titus Law Firm practices all over the state of Texas in a bunch of different areas. Check out our website. But what we are here to talk about today is probate. What is it and how does it work? So, in a nutshell, probate is the process of moving assets from a deceased person to living persons, right? That's probate. Of course, you can't own stuff when you've passed away. You're no longer around, right? You can't take care of it. You can't utilize it. So it needs to go into somebody else's ownership. So how does that happen? Hopefully that person had their estate planning done, but even if they didn't, then there's another process, which is intestacy. And we'll get to that in a moment. But just remember, person alive with stuff, they pass away, probate in order to move it away from the passed away person to the living people. Probate. Now, people hear this idea of passing within probate and passing outside of probate. Let's touch on that for a moment. If something's passing inside of probate, then that means that it has to go through the probate process with the courts and the judges. And if there's not a will, that means it's intestate. If there is a will, that means it's testate. And there's different procedural requirements for how you probate publicly through the courts about the person who's passed away, what they own, and who their stuff is going to, either based off of the will or based off of the law. And so that brings me to the whole idea of testate and intestate. If you are testate, then that means that the person who passed away has a will. Maybe it's a holographic will, meaning that it's handwritten. Maybe it's a will that is not a self-proved will. In Texas, we have something called self-proved, where you have a certain number of witnesses and it's got all the magic language and you've got the correct notarizations and all that sort of good stuff, right? Self-proving affidavit. And then you've got wills that don't have that going on, right? It's still a good will. It just has different procedural requirements at that point. So you have a will of some sort, you are considered testate. You do not have a will that is considered intestate. And so at that point, there's no document from the person who passed away that says, hey, I want my stuff, this is my stuff, to go to these people like this. When you don't have that document, the state still has an interest in making sure that your stuff gets to somebody, right? It just doesn't want a bunch of stuff floating out there owned by people who passed away and can't take care of that property. So what happens? There's the estates code. In Texas, the estates code outlines what's supposed to happen with your stuff if you pass away and you do not have a will. You are intestate, right? So in that scenario, you've got to do a different process procedurally, where now the courts have to determine who are your heirs. Do you have kids? Do you have a spouse, brothers and sisters, parents? Who takes after you pass away and you don't have a will, directing your stuff to certain people? Well, there's this idea of consanguinity. And so the statutes, the code, if you will, of your state is going to say, hey, this is who it goes to in this order of priority. And this is the percentage that they get, and this is the percentage that they get. So that's what happens if you are intestate. Now, after that, you have an executor if you are testate and a administrator if you are intestate, and there's not really functionally different. It's just a matter of how they get appointed, right? And that individual, administrator, executor, executrix, they are the ones who are in charge of all of your stuff in your estate, and they have a fiduciary duty to distribute all of your stuff to whoever your beneficiaries are, right? If it's a will, it's the people that you named, right? If it's an intestate administration, right, then that means it's whoever the judge or the law said is supposed to inherit from you, right? So now you've determined if there's a will, You've filed an application, right? If there is a will, you're testate. If there's not a will, it's intestate, right? Then you notify all relevant parties, and procedurally it differs based off of the will, the type of will, or if there's no will at all, right? And then there's a time frame in which people can contest the will itself, right? The beneficiaries, or if it's intestate, it would be incorrect to say the court's determination because the court doesn't make a determination until it has all of its evidence. But during the intestate phase of the determination of heirship, determining who are your heirs, that's a point at which people can say, have their, have their thoughts heard, their arguments heard about who is or isn't an heir, if that's at issue. And then they get a second bite of the apple once you're talking about the divvying up of assets and the administration of the estate, about who should be appointed, and if there's some reason why somebody who is an heir shouldn't receive a certain something or the other. All of that happens in between determination of heirship and the appointment of the administrator, right? And so after that time frame for contests, then you appoint that administrator or executor. When I say you, courts do it, right? And then after that person then manages the estate and they distribute the assets. So that's the probate process, very high level, without getting into the granular details. But the idea here is that you need to have a will. You should have a will. So it's an easier road for your loved ones to travel once it's time for them to probate, right? Okay. So we've covered what probate is. We've covered what it means to pass inside of probate versus outside of probate. And we've talked about testate or intestate, right? And then I've given you a very brief overview of what the probate process looks like. I guess the last thing to answer would be the most common of all questions. How long does it take? That's different from county to county and from state to state. But here in Harris County and the surrounding counties in Texas, I would wager a guess that a uncontested probate should take somewhere between 3 to 6 months, right? If it is a intestate matter, you have to do a determination of heirship and then administration. I would wager the guess that, again, if it's uncontested, it should take about 3 to 6 months. In both of those scenarios, will or no will, if it is contested, there's no way that I could give you a guess of how long it'll take. At that point, it turns into straight up litigation, and it could go on for years. It could settle in 2 weeks, right? Just don't know. So that's probate. All right, follow the Titus Law Firm, and we'll be posting more soon.